Good morning friends, welcome to the YouTube channel Advocate Amit Kumar Gupta. In my series on the income tax cases, the case which I am going to discuss today is G. Ravishankar versus Income Tax Officer. The case has been reported in 445 ITR at page number 296. The matter has been decided by Madras High Court in a writ petition and the case has been decided on 21st April 2022. This judgment is not very long as far as the pages are concerned in which the judgment is running. This is a very short decision. In this case, two small issues were involved. In this case, the notice was issued to the assessee under section 148A clause B on 17th March 2022 to give the reply on 21st March 2022. Meaning thereby that only 4 days was given to the assessee to give reply. But as per the mandate of section 148A clause B, the assessing officer has to give a minimum period of 7 days and maximum period of 30 days to the assessee to reply to the notice under section 148A clause B. So the court quashed the order under section 148A clause D on the simple reason that the mandatory period of minimum 7 days was not given to the assessee to give the reply. Apart from that, in this particular case, the assessee submitted its reply through speed post and it was clear from the facts of the case that the speed post was received by the income tax officer. But the assessing officer did not consider the reply by saying that this reply was not received through the e-portal. So the question involved was that whether department was bound to consider this reply if this reply was not received through e-portal. So on this issue, the Madras High Court said that if the assessee has sent the reply through speed post and not through the e-portal, and if the department does not consider this reply before passing the order under section 148A clause D, then it is against the principles of natural justice. And natural justice is one of the strong pillars for entertaining a writ petition of the assessee. So in this particular case, the Madras High Court entertained the writ petition of the assessee by quashing the proceedings under section 148 and give the directions to the department to reconsider the reply of the assessee. Friends, the main motto of discussing this case is that whenever there is a procedure into the law, that this procedure is to be followed. Like in this particular case and in this particular section, section 148A clause B, that you have to give a minimum period of 7 days, then you have to give minimum period of 7 days. There is no escape from it. There is a Supreme Court judgment that if a prescribed procedure is there, then it should be followed. No other procedure is valid. Only that procedure is valid. So on this ground itself, the Madras High Court quashed the 148 proceedings. And in this particular case, when the assessee sent the reply by the speed post, the court said that you were aware that the assessee has sent the reply and you were bound to consider the reply, although this fact was also clear that assessee has to reply to the e-portal, but in any case, if the assessee is not able to submit its reply through the e-portal, then and he has sent the reply through the speed post, and if you have received it, then you are duty bound to consider this reply in passing any order consequent to that submissions. Friends, this case is very important because sometimes it happens that suppose if the assessee has not asked for virtual hearing, so the question arises whether the department has to compulsorily give a virtual hearing. So it is the duty of the department whether the assessee has asked or not. There are some cases which says that despite that the assessee has not asked for the virtual hearing, then it is the duty of the department to give the virtual hearing. If the assessee has sent you reply through the speed post in any of the circumstances, it may be happen that by ignorance or something like that, or the portal is not working, then if you have received the reply, then you are duty bound to consider that reply before passing the order. Friends, this case is very important in the new regime because we see in our assessments and e-proceedings that the department give very short period of time to submit the replies. Friends, once again I am repeating the name of the case. The name of the case is G. Ravisankar versus Income Tax Officer, and this case has been reported in 445 ITR at page number 296. Thank you, friends.